you need to be nice to each other, you need to be nice to the children, and you need to not move money around or steal from the other person.
What are temporary orders and how do they affect the divorce process in Texas? We're going to talk to attorney Erin Leake about that on today's Ask the Lawyer. Erin, thanks for joining us.
Thanks for having me.
So first off, when you file for divorce in Texas, what are some of the things that happen immediately? And also, what is the status quo and do both parties have to keep it?
I'm going to take those one at a time. So immediately when parties file for divorce in Texas, especially in Central Texas, all of the counties have standing orders that go into place. And those standing orders are about 4 to 5 pages long and have a bunch of different things in them. But in general terms, you need to be nice to each other, you need to be nice to the children, and you need to not move money around or steal from the other person. Okay, so that goes into place immediately as soon as the divorce is filed. Then there are other orders that we can go and obtain called temporary orders. And those orders are intended to cover what needs to be dealt with while we can get the divorce done, while we get all of the things we need in order to complete the divorce. Those temporary orders normally relate to the children and the house and bills. Those are the 3 main things those will relate to. The status quo, that's going to be what is happening right when we file for divorce. So what has happened previously with the children in terms of possession and decision making for the children, how have bills been paid previously, and has someone moved out? Are you both still living in the house? That's going to be what the status quo looks like. The courts do like to maintain some amount of status quo while going through the divorce. We don't want to upheave everyone's lives as much as possible. And so that's why the status quo is important on that first temporary orders time period.
So can you talk about, what about in situations where one party has moved out and some of those marital bills are no longer being paid, stuff like health insurance or a mortgage on the house?
That's actually a great time to go and seek temporary orders in a divorce case. The court, as we spoke about before, wants to maintain the status quo, and they also want to make sure that the marital assets are going to remain in basically the same way that they were when the divorce was filed, so that we can split them upon the divorce being finalized. So we want to make sure that bills are being paid. We want to make sure the mortgage is being paid, taxes are being paid. We don't want anyone cut off from health insurance or car insurance or things of that nature. And so the standing order is going to cover that. And so people aren't supposed to change any of those things under the standing orders, but that doesn't always happen. And so if someone is not paying bills, that's a great opportunity to go ahead and seek relief from the court and ask the court to order those bills to be paid or make a decision on how those bills are going to be paid.
And in cases where there are children involved, what happens if the parties can't agree on a parenting schedule or maybe custody? Is something like mediation appropriate in those situations?
This is another situation in which we do go and seek temporary orders. And temporary orders can be either an agreement between the 2 parties. We can agree to make temporary orders, or we can go to court and ask the court to make those temporary orders for us. Sometimes we do utilize mediation for temporary orders to help the parties reach an agreement for that. But most of the time, if we aren't able to reach an agreement, then we're going to have to go to court. The court at that point under temporary orders can decide possession and access, which is what time is each parent going to be able to spend with the children. And then they can also make decisions regarding conservatorship, which is what decisions are each parent able to make for the children while the divorce is pending.
And also child support is a big topic too, a big issue. How is that determined when a divorce is first filed? And how is that determined when maybe one parent is a stay-at-home parent versus both parents who are working?
So child support is another issue that can be determined upon temporary orders. And it's a little different than how we do it when we're actually going to finalize the divorce, which we just use the Texas Family Code and generally guideline child support. When we're in under temporary orders, all the income that is coming into the marriage at that point is still considered community property, which means that we can all of the income can be used for the support of the child. So sometimes the court is inclined to just order guideline child support, and other times the court's going to give a deeper dive into the party's budget and their finances to determine how are we going to meet these child's needs. Is it possible for both parties to meet the child's needs while they're in possession of the child, and we don't need to have child support ordered? Or in the case of like maybe a stay-at-home parent, they're going to go ahead and order child support to be paid from the working spouse to the non-working spouse. And it might even be in excess of what would be under guideline, because we want to make sure that the status quo is maintained for that child while we're going through the divorce.
And Erin, obviously there are a lot of moving parts here. How long does this process usually take? And what happens to those temporary orders once the divorce is finalized?
So we try to get you into temporary orders pretty quickly. It's going to depend on what court your case is located in, but let's say in Travis County, we're going to try and get you into temporary orders within 30 days after you file. Some other counties have a little bit more of an extended time frame, but we're looking at several months at the most in order to get those temporary orders. If there's emergency matters, the court can hear those pretty quickly, almost within a week or so, if we need to have those heard on a temporary basis. At the end of the divorce, the temporary orders are going to be dissolved, which means that they go away. The divorce decree, your final agreement or your final order that the court has made, is going to take over at that point, and the temporary orders are going to no longer exist.
And as far as the length of the divorce process, I would guess that depends on the case.
It does.
That something you see?
It does, I would say, depend on the case. I would think right now we're seeing about a minimum of 6 to 8 months for the divorces. I think that's a holdover a little bit from COVID. But I have had cases done faster than that. And then I've had cases that have taken years. It's really just going to depend on the facts of your particular case.
Erin, thank you so much for taking the time to talk to us.
Thank you for having me.
And that's going to do it for this episode of Ask the Lawyer. My guest has been attorney Erin Leake. If you'd like to ask her about your situation, call the number on the screen. Thanks for watching. I'm Molly Hendrickson for Ask the Lawyers.